Okay, I have 11 o'clock. Welcome, everyone. I'm Suzanne Stoltenberg with NFIB Pennsylvania, and I thank you so much for joining us. This webinar is on business succession planning, and we have an excellent presenter today. It's Vance Antonucci, and he is a specialist in an attorney who specializes in estate planning with McNees Wallace and Nurick, which you may be familiar with in Pennsylvania. I'd also like to thank our sponsors at this point. They include McNees Law Firm, as well as Pennsylvania Manufacturers Association, Capital Blue Cross, and Members First Federal Credit Union. I wanted to ask you today as we go through, if you have any questions at all, we're going to try to answer them, and you can type them in and hit enter, and I shall see them and alert Vance that you have a question. And now, Vance, I'm going to turn it over to you.
Well, thank you very much, and thank you for having me. Certainly, questions would be welcome, and a great addition to the conversation here. Hopefully, it's interactive. So, what we're going to cover today, just as the title indicates, is succession planning. And this first slide really covers the big picture, and these are the main things that really, in my experience and with business owners, come into a plan. And we're going to cover each one of these in a little more detail, but just to give you an idea of what we're going to look into, I mean, the first thing is the timing. When should you start, thinking about this, and what does that mean, and who should you involve, and how important is that to, who are the right players? Basic estate plan documents. Much of what you address in a succession plan are, unfortunate, untimely events or unfortunate things, and without a basic set of estate plan documents, you're going to have a very hard time of, putting the broader plan in place, which it really is a layer on top of the basic estate plan. Probably the meat or the heart of what we talk about in a succession plan are buy-sell agreements and how life insurance factors into that. Many buy-sell agreements are, they're triggered by a death, obviously. There's also a disability and voluntary exits from a business. And that really is the document that governs a lot of important relationships and events in your business. Real estate. Many people that I work with and many business owners in general often own the real estate where their business is located. The real estate may or may not be part of the succession plan, and it's generally a pretty important piece of the puzzle, both from a financial and legal perspective. Financial planning for the owner. When you're exiting your business, what does that mean for you financially? What do you need to live on each month? How are you going to cover that set of expenses? And without an active income anymore, what does that mean for your lifestyle? Family members. Many businesses I deal with, almost all of them, not all of your children typically work in the business. Now, sometimes that's not the case. But if it is the case, how do you pick and choose among those 2 or 3 relatives that are in the business as far as who's doing what and who will have ownership? And the other question I generally challenge people to answer is, is a family member the right person to actually lead the business? Which many family businesses don't have family members at the helm anymore. And then plan transitions. I mean, buy-sell agreements often address, the what-ifs and the worst-case scenarios, but, generally those things don't happen, and we are trying to structure then a plan for an orderly lifetime transition of someone's business, which has a lot of different income and estate tax consequences, can have gift tax consequences, and of course factors into all these other things we're talking about, like financial stability and, who's going to take the leadership and the ownership. So with regard to timing, there are a couple things I try to, get people to think about. I mean, the first thing is when. And I really think it's sort of cliche, but it's never too early to start. you really want to always be thinking about, all of the contingencies that face your business and can challenge its success and create risks for the business. And of course, your death or untimely disability could be part of that. If it's a planned transition, generally speaking, you're going to want to look, I'd say at least 3, probably more like 5 to 7 years down the road. The legal work, doesn't really take that long, but it often takes that long to transition management and leadership, institutional knowledge, to get your third parties and your vendors comfortable with the change of leadership and ownership, whether that's a bank or a key customer or whoever you're dealing with on the outside. I guess we're going from the bottom up here. So setting goals and objectives, I think it's important once you start that process to have a very clear timeline. And that timeline, again, could be years, and the goals to achieve could be, spaced months apart. But that's just another reason to get started early. Your professional advisory team, I generally, when working on a succession plan, the company and family accountant is involved. They generally have the most knowledge of anyone because they are doing the tax returns every year. Perhaps there's an audit. They really have their hands on the numbers. Typically, you need to engage bankers or whoever is extending credit to the business or you personally to understand how the transition is going to affect the extension of credit. You don't want credit to be cut or affected negatively, for obvious reasons. And if you're transitioning into a new phase of your life, retirement, you often have a financial planner involved who's going to help you with a budget and understanding cash flow and modeling out, different scenarios for you. Some of the issues that typically come up then with a plan are, how do you hire, compensate, and promote family members, and whether, of course, you're going to have family or non-family managers. And family, of course, can include in-laws. I have lots of clients where it's a son-in-law or sons-in-law who are in business and have management, may not have ownership, but certainly are key employees. As far as hiring and compensation and promotion, a lot of people will say, well, look, I don't want a family member to work here unless, for example, they've worked somewhere else for 2 or 3 years, or they have to have an MBA, or they do something else to, demonstrate to the other employees and executives that they're not getting a job solely because they're related to me, the business owner, and that they are qualified and that they are, achieving on a merit-based, situation. And that feeds into compensation and also feeds into promotions. I think the last thing you want to do is set up a situation where long-time key employees feel like they're getting slighted simply because they didn't win the DNA lottery, as I like to say. So it's very important that there are clear rules as to how people get into the business, how they stay in the business, and how they succeed in the business. So as far as a basic estate plan, on the one end of the spectrum, a lot of times with succession planning, especially in more valuable businesses, you have a lot of trusts that are involved of all shapes and sizes, and that's kind of beyond the scope of today's discussions. But trusts can play a very important role in a succession plan and an estate plan. But at the very least, whether you're you or me or Bill Gates and Melinda Gates, these 3 documents are the ones you want to have. So a last will and testament controls at your death the disposition of your individually owned assets. Now, most couples have the property is jointly owned, so the surviving spouse becomes the sole surviving owner of a bank account or your house or whatever it might be, a beach home. But more often than not, the business is owned by one spouse or the other. So you need a will to tell the world, where that buy-sell payment goes or where the ownership of your equity ends up, typically to your surviving spouse or to your children or wherever that's supposed to go. Or if, for example, you want to specifically give equity to one child instead of another, and whether or not your spouse survives, all that's spelled out in a will. A durable general power of attorney is the document where you appoint someone to make financial decisions for you if you cannot do so for yourself or you don't want to. Many business owners will split out the business aspect of that, and what I mean by that is they'll have two powers of attorney, one for sort of day-to-day household type stuff, bill paying, dealing with your vacation home, etc. And then they'll have one that's specific to the family business, so that the person appointed under that document would step into the owner's shoes as a shareholder or an LLC member or a limited partner to do whatever needs to be done if for example, that person is incapacitated. And a living will, or what I would typically call a healthcare directive, is the document where you tell the world and appoint an agent to carry out your wishes with regard to end-of-life medical care. It really doesn't build into a succession plan so much, or because that's sort of the worst. And then you're obviously terminally ill. But nevertheless, that's the third leg of the stool with a basic estate plan. With regard to a buy-sell agreement, a buy-sell agreement to me is sort of a general term that encompasses any agreement between one or more owners of a business as to how the ownership, the equity, can be bought and sold, if at all. So it could be encompassed in a shareholders agreement. It could be encompassed in something called a restrictive stock agreement. It could be in your operating agreement if you're an LLC. It would be in your partnership agreement if you're a partnership. But the buy-sell terms are sort of stuffed in these, generally put into these other documents. You could simply call it a buy-sell agreement, which you often see as well. The main thing, or one of the main things that the buy-sell agreement tackles is, what causes a required sale and a required purchase under the document. So some typical ones you see are bankruptcy. If an owner ends up in bankruptcy or is insolvent, you don't want the owner's equity ending up in a bankruptcy estate and therefore being subject to the rules and regulations of a bankruptcy court and a judge. So often the event of bankruptcy or insolvency requires that particular owner to sell back his interests, and then what's left for the bankruptcy estate is the promissory note, the promise to pay, or the actual payment for the equity itself. Other common triggering events are disability, which you don't always see. Maybe for younger owners who are very active in the business, if they're disabled for say 4 months or a longer period of time, they're not contributing anymore to the growth. They should be bought out. With an older owner who perhaps has been transitioning management or ownership to younger generations, you may not have disability as a trigger because it's more likely they might be disabled, but yet they're not contributing as much. So you might carve them out. Other common triggering events are divorce or any court-ordered transfer of your ownership. So, typically owners are very comfortable with working with each other, but they don't want to be in business with someone's spouse, particularly if that spouse is divorcing the other owner. So if in the event there is a court order to transfer property as part of a marital estate, that will trigger a buy-sell event. And then, last but not least is death, and that, is sort of the most unfortunate event. But if an owner unexpectedly dies, you want assurance as to what is going to happen to the owner's interest. So that bleeds into, how do you, pay for it? So on the one hand, if you don't have an event of death, you can get insurance to cover those types of events, but it's typically very expensive, and I don't usually see it. You can buy a disability policy that would pay out a lump sum if another owner becomes disabled to enable the buyout, just like life insurance. But I typically don't see that. You typically have seller financing, which we'll talk about in a second. And of course, if it's death, you typically have life insurance to often back up that obligation. So a number of things have to be worked out in the buy-sell agreement, and the more you can work out in the agreement, the better off you're going to be, because I always tell people that if you have one of these events that are unfortunate and unexpected, the last thing you want is uncertainty to compound the crisis that's happening or coming about. So you have to think about, well, first is that you could be on either side of the transaction. You could be the buyer, or you could be the seller. So you really need to be fair, because you don't want to overpay if you're the buyer, and you don't want to be underpaid if you're the seller. But one thing you have to think about is, what is the down payment? Is it 10%? Is it 0? Is it, where does that money come from if there is a down payment?
Vance, could I jump in and ask a quick question? It's Suzanne.
Yeah.
So is there, do people, when they're in this situation, can they write in there that they want some kind of an analysis or evaluation of the value of the business at that point from an independent person?
Yeah, so that's jumping ahead a little bit. It's a great question. Typically, in the agreement, one of the things you specify is how the purchase price is figured out. So the way I generally approach it is I say, look, the owners every year are going to sit down and agree on what the business is worth. And I think that's a good, it prompts a broader discussion about, how was last year, how can we improve sales, so on and so forth. If they happen to not do that for, say, a period of, 15 months, and an event happens that requires a buy and a sell, I generally give them a window of time, like 30 to 60 days, to reach a mutually agreeable price, because I don't want to force them into getting an independent appraisal if they don't have to. If they can be reasonable and agree on a number, that's great. But if not, then the backstop is you go out and get a third party to value it. And the reason I don't want to force them into that is because that third party valuation, is going to cost you $7,000, $8,000, $10,000.
Right.
And then what you typically, sorry, go ahead.
And one follow-up on that, you pointed out about the life insurance. So I'm assuming it's advisable to anyone who has partners, be they family or other partners, that they would have a life insurance policy approximately of half the value of their business. Would that be normal, or do you see that people don't think about that?
Well, both. Yes, I guess it's not normal then. I generally encourage people to get life insurance, and I'm not licensed to sell life insurance, and I have no skin in that game. But if death happens, it is often nice to get that big lump sum payment, whatever it might be. And typically, what you see is term life insurance, which is the least expensive kind. You try to buy a term that's long enough that will probably cover your time horizon as an owner, the lifespan of your career, so 20 or 30-year term. But some of the you could have someone who's uninsurable, or not in great health, or a cancer survivor, so it makes the insurance very expensive. So they perhaps can't get an equilibrium, for example, on what everyone has. It's a cash flow issue. You cannot deduct the payments for life insurance for income tax purposes. So it's it's $1 in the door. If you're an S corp or a partnership or an LLC, you pay tax on that dollar at whatever your effective pass-through rates are, and then you turn around and buy life insurance on a non-deductible basis. So it can get expensive quick, particularly if you have a big business. But I generally like to see it in place for that reason. But that's really what and then if you have multiple owners, which this comes into, whether it's a redemption versus a cross purchase. A redemption is, the company buys your equity when you die. So the company owns the life insurance pays into the business affects the purchase. So if you have 5 or 6 owners, that's a lot easier because you have, 5 or 6 policies and that's it. A cross purchase is, each owner has a right or an obligation to buy the other owner out. So in my example, if you have 5 owners, you would need 20 life insurance policies because each owner would have 4 policies, one on each other on the other guy. That can be a bit cumbersome. Now there are ways around that. You can create a separate partnership just to own the policies, and I won't dig too deep on that, but there's an easy way around that cumbersomeness. With the redemption and a cross purchase, the main things to think about are this. A lot of times I see these buy-sells drafted as, the corporation has the first crack, and if they pass, the shareholders get a chance then to buy it. If the life insurance pays into the company, the life insurance is now cash, and the cash is collateral. I mean, if you have any secured creditor, like a bank, the $1 million payment you just got in is cash. That's collateral for the debt you owe back to the bank. That secured creditor, it takes precedence over the deceased owner as a creditor. And I've seen situations where the bank was very difficult in allowing the redemption to occur. And particularly if your business isn't doing great, you're going to have a lot of trouble getting that cash off your balance sheet to carry out the purchase. And that's always a concern of mine. So a cross purchase, which happens at the owner level and doesn't, the life insurance proceeds don't hit your balance sheet as a business, doesn't have that same issue. Now, I guess if you have secured personal guarantees, arguably it's a problem. Most personal guarantees are not secured. I mean, if you have to give a secured personal guarantee, you're probably not that creditworthy anyway as a business, and you probably have bigger problems than figuring out how to buy, sell. But so I typically, I like to see cross purchases. You also get an income basis tax step up for what you're buying, where if you redeem the shares or redeem the LLC interest, the basis just disappears, so it's not as income tax efficient. The one other thing to be careful about with the purchase price is you have to be reasonable. And I see a lot of times like people default to 2 times book value or 1 times earnings or something just that's really not clearly undervaluing the business. And the problem you have is that that contractual obligation, that's a deal between you and the other shareholders, the other owners. That is what it is. The IRS or the PA Department of Revenue doesn't have to accept that valuation. So you could have a situation where there's an underpayment for equity, and the person who sold, the decedent, got, say, $1 million, but the business is really worth $5. Now the IRS comes in and says, no, we're going to tax you on $5 million. Well, you don't have the money to pay the tax because you didn't get a good enough, you didn't get a high enough purchase price. You have to be very careful about trying to game the system with the purchase price. And plus, I don't know why you'd ever sell something that's worth $5 million for $1 million. It doesn't make any sense to me, or whatever the numbers might be.
I suppose if it was your child, you might.
Well, but there you're getting into, true. But you have to just counsel people that you might be having a situation where it's a partial gift, which is okay. I have a lot of gift sale, combined gift sale things. But you don't want to whip the, you don't want to. I have a partner who always says, you're too smart by half. So you don't want to set up a situation where your surviving spouse, kind of gets shortchanged and then has a tax problem on top of it. That just is a double whammy that you really want to try to avoid. And there's a lot of gray in there, and it's, I mean, you really got to kind of lowball it to make it worth the effort of the taxing authorities to chase you. But you don't want to be the test case, I always say. So, and then last, but with seller financing, you always want to talk. You want to think about, what kind of, you're that person's creditor. Do you want to be secured? Where the payment's going to come from? That kind of stuff. And that just again is, if the company's cash flow can't support the purchase price, well then you might as well not. You better start over because that's where the money's coming from. Real estate is something else that I see, quite a lot. Many people that have the operating business in one entity and they separately own the real estate and lease it back, which is a great income tax play. Um, Typically, I'd say more often than not, you don't see the real estate being sold along with the business because the buyers in a lifetime transaction or even a transaction at death, don't always have the capital to pull off both right away. And the surviving spouse or the owner who's exiting during his lifetime, probably wants to rely on that rental income as part of his or her retirement package. That nice stream of monthly rental payments is a nice boost for for many people, and it's part of what they're expecting to have at death or in their retirement or at death for their surviving spouse. So if you're planning for a transition, you probably want to have a decent lease in place. You don't need it if it's within a family. You don't, of course, need it to be like the kind of lease you might see in a true arm's length transaction. But you want some certainty that the rent is going to keep flowing in, and that the lease is probably triple net, and insurance is required and all that stuff. But that's usually something that's overlooked. If the real estate has debt, you obviously want to make sure that you have enough cash flow, enough rental payments to service the debt, or you're going to have big problems. Another thing I try to work through with an owner, and it's almost as much of a management issue and not so much a legal issue, is what I call capital needs versus shareholder liquidity. So many business owners, to their credit, have a lot of confidence in their businesses and believe that leaving money in is just as good as putting it anywhere else, whether it's the stock market or any other investment. And often they're right. But there always is this struggle with, or this tension of, the more money you leave on your balance sheet, obviously you need less outside financing, you have more working capital, but your risk is concentrated. The more money you have in, you're less diversified, and of course everyone probably knows the importance of diversifying an investment portfolio. And maybe you say to yourself, well, my diversification is I have the real estate. Well, if that's the real estate where the business is located, it's really not that diversified, because if the business can't pay rent, you're not going to collect rent. So shareholder liquidity really is pulling money out at appropriate times and then deploying that capital elsewhere, whether it's the stock market or another business opportunity or something that kind of puts your eggs in a few different baskets. But it's hard, sometimes, and it's not a weekly conversation. It's more of a, here's our 1-year budget, and here's our 5-year plan, and it's just planning for your business as to what you think the capital needs are. I mean, everyone has CapEx. Do you lease versus buy? Do you finance versus internally financing? And all those things impact the amount of money you can pull out, whether in wages or distributions. The other thing I often see with a transition is, the psychology of the business owner. And this, again, it's not a legal issue, but a lot of times it's difficult, and understandably so, for the business owner to pull back. You've been there for 40 years. It's a lot of sweat equity, and it's hard sometimes to make that adjustment, that transition to turning over the reins, moving into retirement. Maybe coming in 1 day a week instead of 6 days a week, and spending time in Florida or wherever your vacation home might be, or whatever you're into. That's a tough thing for people to do typically, and I understand that. But it's part of the reason why you start early. You try to develop good leaders. I always joke that I in any meeting I'm in, I want to be the dumbest person in the room, which tells me I've done the, surrounding myself with smart people, and that's a good thing. So leveraging people around you and the intellectual capital in your company is very important, and that hopefully can allow you to have a little more certainty and confidence in transitioning. The other thing that we see a lot of is this tension of family versus non-family, and again, it could be as simple as which of my children do I elevate? You kind of need one cook in the kitchen or one captain of the ship, and sometimes it's very easy. One of the children likes working out in the shop or in the plant or doing whatever, and the other one is clearly management material. It can be a son-in-law. or sons-in-law, which is a little bit of a wrinkle. I mean, you have then sisters or even brothers who may not like each other or get along or feel like they're they should be in the business instead, or why is it my spouse and not me? And that can create a whole separate different set of dynamics. I have a couple, well, more than a couple businesses that I work with where the son-in-law is an employee of the CEO, and his wife, in the cases I have, is one of the majority shareholders, which can create tensions, but not always if it's handled properly. The other thing I try to encourage people is, just because you haven't identified a family member doesn't mean the business, has to be sold to a third party. That can be your exit strategy, is selling to a third party. But you can groom someone to take over, and maybe they get some phantom stock or some kind of incentive to put sort of looks like sweat equity, but they're not necessarily an owner. And then your family members can sort of reap the rewards of equity growth. They would be on the board of directors or family council, whatever you want to call it, and meet quarterly, but the business and its employees continues on. And I typically, one way I often try to motivate people to plan is like I say, look, forget yourself. But you have 100 employees, and that's 100 people that have 300 family members, and that's 400 mouths that you feed. So you need to plan to make sure this thing continues, because if you don't continue, they don't have jobs. And most people I work with have lots of long-term employees who they think a lot and really appreciate, and that can often resonate with them. So it's important that whoever ends up running it, that the show goes on, and that whether it's a family or a non-family member, it really shouldn't matter. It's the people that are behind it that should matter. Because whether or not your kids are involved in a management position or as employees, they can still get the equity benefit, and you can still have involvement. And I can think of a couple of very large companies across Pennsylvania that are set up like that I don't necessarily do work for, but they're really big organizations where there's if it's the Smith company, there's no more Smiths that are involved as employees, but there are a bunch of Smiths who are on the family council or the board of directors who have ultimate management and responsibility duties. And if you have a family constitution or something like that, that can help frame what are everyone's expectations and obligations. So planned transitions are often probably more than anything what we do, at least I do. Fortunately, I don't have a lot of unexpected deaths or disabilities. So starting from the bottom again, if you can have a sale to a third party. I mean, that is, if you can find a private equity firm or a strategic buyer that will pay you sort of top dollar, that's great, and that's part of what we do. If you're going down that route, and there are ways, typically involving trusts, to do some pre-planning where you can kind of carve out and set aside that equity, that big payout for your heirs, or do some income tax planning. There's ways to mitigate the tax consequences. If you're going to sell to a third party too, this again, it's not a legal issue, but you really got to start getting your house in order. I mean, if you're big enough, you may want to start having an audit. If you're not getting audited, you really want to make sure your financial statements are in really good shape. Because that's what your strategic buyer, your third-party buyer, is going to dig into heavily. They haven't been there running the business. They're going to really kick your tires in due diligence, and you want to be ready for that, because everything they see wrong, it's like a death of 1,000 paper cuts. They'll try to knock the purchase price down, or increase the working capital adjustment, or whatever the deal is. But those are an easy way to, not an easy way, but a way to get out of your business if you really have no successor and you really want to monetize your equity. ESOPs, employee stock ownership plans, are also an option sometimes, which is well beyond the scope of this, but that can be for the right business with the right group of employees and the right set of managers, that can be an option for an owner. With regard to family transitions, right now the estate's gift exemption amount is $11 million for a husband and wife, so, well, $10.9 million. So essentially, you can transfer an enormous amount of wealth with no gift or estate tax consequences. If you're beyond that, then, there's other planning you can do. But it doesn't have to be a gift. You can certainly sell your business to your children or other family members, and again, sell or finance it, or if they can get third-party financing, that's great. Although a lot of people want to have that seller financing because they want to spread out their capital gain recognition over a number of years instead of taking it all in 1 year with a third-party financing. You can have a gift sale combination where the business is worth $4 million, but you're selling it for $2 million. There's a lot of fudge in this, but I have a lot of clients that, say the sales price is really $2 million. Well, they'll sell it for $1 million and take a $1 million employment contract. The idea being that it helps the buyer because the payments to buy your business are not tax deductible. Principal payments on a seller finance loan aren't tax deductible, but wages being paid out to the seller as then an employee are tax deductible. So it can help managing the buyer's side of the transaction if there's some wages that are involved. And typically they want that person to stick around for one reason or another. So there often is an employment agreement or a consulting agreement, something along those lines. A lot of times what you see is a recapitalization of the entity. So you have a large block of non-voting equity, and that is what is sold or gifted. And the mom or dad keeps the voting equity for a while so that they still have control because they have the vote, but the 2 or 1% they keep, as the company keeps appreciating in value, it doesn't keep appreciating on their balance sheet, and then therefore mitigates their tax situation a little bit. One other thing we often see too is it's rare you see all the kids in the business. So if there's any kind of gifting at all, there's always this analysis of how do I treat the other kids? Should I make everything equal? Is that fair? And I always say fair and equal are different things. So if you've cut your son a break of $1 million by transitioning the business to him, you may want to do something in your estate plan documents to make that up for the other kids. You may take the approach that, hey, look, a lot of that value was developed by that child through their efforts here, and I'm not going to make them pay twice. So you may not do anything. There's no requirement that you treat all your children equally. A lot of people want to do that for different reasons, but it's certainly not required in Pennsylvania. You can disinherit a child if you want to with there's almost no recourse for that. So I think just to recap briefly, again, start early. Be thoughtful. Get the right team around you to help you out. It's a tough thing to do, and try to be as open as you can with the people that are involved, your children, your spouse. That, as long as you're comfortable with it. I think it's important to have communication, because you don't want to craft a plan you think is great, and you show it to your kids, and they're like, oh, what were you thinking? And last but not least, whatever you put together has to work for you. It's you that built the business, and you that deserve more than anyone to reap the rewards of that effort over your lifetime and the risk you took as an entrepreneur. So at the end of the day, it's got to work for you. That's the golden rule, I say. So I don't have anything else to cover. I think I've hit about my 40-minute mark here, and I don't know if there's any other questions. I'm glad to stay on as long as is needed.
Well, I have a recommendation since we have been recording it and we'll have other people looking at it after the fact. Why don't we ask anyone who has a question? You all have my email, and if you would go to the next slide, I believe I provided my contact information there. Oh, there's yours. Okay. And if you would write down that phone number and or this email, and I often email all of our members, so you probably have my email. You can send me your questions, and I'm sure Vance would be happy to answer them. But anyway, I want to thank you all so much. And Vance, that was excellent, and I'm really glad you used up the entire 40 minutes because it was just so intriguing I couldn't stop to even think of a question. I will be, go ahead.
No, I just want to thank the NFIB, and I mean this sincerely, that it's organizations like yours that really, in my opinion, make this country work, because small businesses and family-owned businesses are the backbone of this, the country we're in. So anyone that advocates for them is a friend of mine, I say. So.
Oh, thank you so much. Well, I wanted to let everyone know, though, that I will be posting this recording on our website, nfib.com/PA, and that usually takes about a day. But if you wanted to review the slides again, or if you have any questions, you can get my email on there too on the contact section. So thank you all so much. And Vance, we're so very grateful, and thank you to McNees Wallace and Nurick as well. Everyone have a great week, and we'll have another webinar in August, which we'll be sending out a note about. Thank you so much. Bye-bye.
Thanks.